Really do.
Thank you, Your Honor. At this time, my client is asking that a preliminary exam be set in this matter. Your Honor, we are asking for this to be set knowing that there is some outstanding evidence. My client has been in jail for 135 days, and we've asked for the DNA evidence multiple times.
This opening moment already reveals a serious issue in the case. The defense is pointing out that the defendant has been sitting in jail for over 3 months, yet the DNA evidence still hasn't been produced in criminal law. That's a huge point of tension. Evidence delays can affect bail decisions, trial timelines, and even the defense strategy. So the question for you watching: if key forensic evidence isn't ready after months, should someone still be held in jail? Let me know what you think.
We just can't get the evidence. Um, Your Honor, I'd also like to address bond when appropriate.
Okay. Well, I'll know because every time we come up to DNA, and I'm not going to ask when it's going to be here because who knows. So
I
that won't be the fact that if he wants an exam, he's going to have it. The fact that they don't have DNA is not going to be the basis for an adjournment. You understand that, sir?
You understand that,
Yeah.
Mr. Johnson? Thank you. Your Honor, when appropriate, I'd like to address bond.
Now listen closely to the judge here. The court is making it clear that missing DNA evidence will not delay the preliminary exam. That's actually an important procedural decision. A preliminary exam isn't about proving guilt beyond a reasonable doubt. It's simply about deciding whether there's enough probable cause for the case to move forward. In other words, the judge is saying DNA or not, the case keeps moving.
Will the people have their witnesses available the 17th? Preliminary examination, March 17th, 2026, 9 a.m. before Judge Moore. As to bond.
Your Honor, my client has currently been in for, I'm sorry, I misspoke, the line above. He's been in for 99 days. My client is very, very confident that the DNA on this particular item is not going to be his. He is asking if he could be tethered to his home. He's willing to do a GPS tether or even a home confinement tether. He does have medical needs that are not being addressed in the jail at this time. I have emailed about that, but there's as the court is aware, there's things that they can do and cannot do. He has significant back pain and various other issues. Matter of fact, the day before this incident, he was at Saint, or what is it, Saint?
Trinity.
Trinity. Thank you, Your Honor. At Trinity before this. So we're just asking that he be released on tether, whichever type the court is inclined to allow. He still has his residency, and he's asking to be released.
Here, the defense pivots to a very common strategy: requesting release on a GPS tether or home confinement. They're highlighting medical issues, back pain, and the claim that the jail isn't addressing those needs. Courts often weigh things like health conditions, length of detention, and community ties when considering bond. But there's another factor that can completely change the outcome: the defendant's criminal status.
Something people. Most of the bond reductions in the bond will continue. March 17th before Judge Moore.
Thank you so much, Your Honor. Thank you. They don't help.
Court calls case People versus Jasmine Morris.
And Assistant Public Defendant Nicholas Buckovich on behalf of Mr. Naparilla, who is now approaching. Please state your name for the record.
Michael Naparilla.
I have before me a plea form that indicates that he's going to be pleading guilty to count 2, I think, of use of fentanyl, the 1-year offense. Upon the successful proof of that charge, count 1 would be dismissed. There's an agreement to no upfront jail.
That's correct, Your Honor.
All right. Let's have him sworn.
Michael Naparilla.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of fentanyl. That's a misdemeanor, punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that? Understanding that you still wish to plead guilty?
And there it is. The prosecution points out the defendant was already on parole at the time of the incident. That's a massive red flag, and bail decisions judges tend to view parole violations as a sign that someone may not follow court rules if released. So even though the defense argues for tether release, the judge keeps the bond denied. That's a classic courtroom balancing act individual hardship versus public safety.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Or had one signed on your behalf, is that correct? Any question regarding any of those rights? Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights in it. You understand giving up your right to appeal of right. Are you on probation or parole?
Parole in Ohio.
Okay. At the time of this offense, were you on parole?
Yes.
All right.
They're aware of it.
Okay. I do have to advise you that this could be considered a violation of your parole. If it is considered a violation, they could sentence you to the remaining portion of your term or send you back to do the remaining portion of your term or any other sanction in Ohio which would be available to them. You understand that? All right. And understanding that you still wish to plead to this charge? Anybody promise you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will,
Yes, sir.
and because you believe that you are indeed guilty of this offense. On May 25th, 2024, at the location of Gulfside Road, Pittsfield Township, Washington County, State of Michigan, did you have fentanyl in your possession? Did you use it? Did you know what you were using was fentanyl? All right. Sir, if I accept your plea, between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined under Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand this? Counsel, are you aware of any other promises, threats, or other inducements which would lead to this?
No, Your Honor.
And have I complied with the
Yes, Your Honor.
court will accept the defendant's plea to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14-1 probation. Sentencing in this matter will be March 25th, 2026, noon, before noon.
Your Honor, may I address bond when appropriate? Your Honor, at this time, I'll be requesting a personal reconnaissance bond. Mr. Naparilla does have gainful employment. He does have a support system through his partner as well as his family. This case was just now reduced to a misdemeanor with an agreement for no upfront jail time. He will be willing to go and test and comply with any of the court's orders. He would test clean, obviously, as he has been in custody for this amount of time. He does have, again, gainful employment, a car, a support system. He'll be willing to
Aren't they gonna take him back to Ohio?
No. My wife had talked to my parole agent. They're not worried about it just because since I went to jail in parole, they knew about this charge when I was released. So they're not basically worried about it.
And he did, and extra does show that the parole hold from Ohio was lifted. His parole agent did lift his hold, so he has no hold currently.
I don't need a request from him. I'm gonna deny the request. I won't even consider release until such time as he's in the probation.
Understood, Your Honor.
Then that should happen. Quick cause case, People versus Michael Roseberg.
Judge. Court shall feature assistant public defender. Please state your name for the record, sir.
Michael Eugene Roseberg.
Okay.
Yes, sir.
Thank you, Judge. I did speak to my client. I believe she is requesting this matter I believe we're requesting this matter be set for preliminary examination. To my knowledge, all discovery is complete. And I believe Mr. Roseberg would like me to address bond when you're done.
Other witnesses available 17. Preliminary examination in person, March 17th, 2026, 9 a.m. before Judge Moore. That's the bond.
Thank you, Judge. He did meet with Mr. Niskar from our office this morning, and he did actually address his bond. He indicates that he is currently employed, fully employed as a night auditor.
desk clerk for Quality Inn. He still has that job available to him right now. He'd like to make sure he keeps that job. He does have 4 children, 2 of which he supports via child support payments. He wants to make sure he doesn't get behind on those as well. Indicates he was last in trouble back in 2004 for a charge that has been resolved. He additionally indicates that he has his own place of residence right down the street here on Carpenter Road, and he would not have any contact with the alleged victim should the court release him. He would have no problem with a tethered home with work release, and he indicates he would appear for any and all court dates and follow any and all court orders. He'd expect either the PR bond or a $5,000 bond. He believes he can afford to post that if the court does grant a bond, Your Honor.
I'm judges point, kind of this offense for the police work, so we go for kind of a lot of their work, and they're treated because when they are out of the friends while driving home, one person driving there, three of the ones they sorry, they were assaulted. One of the biggest forehead, the wrong eye goes to her arm. Forehead. He also has pulled out Adrian from disorderly crocodiles and the for $500 for assault with breaking and entering. No one was black enough to die. One assault, felony firearm, and larceny for pregnancy, domestic job, stop second. It was $30, $50,000 would be our.
I don't have anything further, Judge.
Motion for bond reduction is bond. Thank you.
Thank you, Judge.
Thank you. Sharon?
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Sharon. Would you say your name, please, sir?
I'm Sharon.
Okay, I have before me a plea form that indicates that he's going to plead guilty to an added count 2 of entry without permission, a 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement. Is that correct?
That is correct.
We have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth?
Do.
What's your name, please? What's your name?
I'm Sharon.
All right, Mr. Sharon, it's this court's understanding you're going to plead guilty to the charge of entry without permission. That's a misdemeanor, punishable by up to 90 days, $500 fine plus court costs. You understand that, sir?
Yes, sir.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed or had signed on your behalf an advice of rights form?
Yes.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights contained on that form. You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
On the date of February 18, 2024, Wise Hall at EMU in the city of Ypsilanti, Washington County, state of Michigan, did you enter those premises?
Yes, sir.
Did you have permission to enter Wise Hall?
No, sir.
But it wasn't. Was it open to the public at the time?
Yes.
Or
I don't believe the hall is open to the public. It may not have been properly closed.
My understanding from your job is that
So
sure.
So you did not have proper access, but entered the building anyway.
Yes.
And you knew you didn't have authority to enter the building.
Yes.
All right. Sir, if I accept your plea, between the time that I accept your plea today and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would have to advise you that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that? All right. Counsel aware of any other promises, threats, or other inducements which have led to this plea?
no, thank you, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14E2 probation. Sentencing in this matter will be March 18, 2026, 10 a.m. before Judge Brown. Bond continued.
Your Honor, may we address bond?
You may.
Your Honor, Mr. Sharon has indicated that, unlike at the time of the incident, which was, I believe, in 2024, he can stay with his sister who resides in Gardens. He thinks that he will return for all court dates. He will either be able to walk or take public transportation or have support from family. We are asking that the court consider a PR bond, especially given the change in the charge.
Well, he didn't appear before, right?
Correct. That is correct.
Because he started out with a. So what you're saying, what changed from that?
He can reside with his sister, so he has a more stable situation.
Well, I would have known, where's this city?
Garden City?
Well, I'm not going to change his bond. I will view it at that. Certainly, you can address that with Judge Barr, too. But with his history before me at this point, I'm not going to change the bond. Thank you.
Thank you.